Hear ye, hear ye. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution is on the court.
Welcome to the First Court of Appeals. We have only one case on our docket today, which is Elma Rivera and Cassandra Morales Rodriguez and Israel Morales versus the City of Houston and Veronica Romero. Before I take the announcement of the parties, I don't know, you probably haven't been told, or no one's advised you yet, that Justice Lloyd is the third member of the panel. He's unable to be here today, but everything is being recorded, and so he will listen to and watch the entire argument, so you won't miss out that way. And it seemed better to go ahead and get it done than to try to find a time to collect everybody on Zoom. So here we go. And if I could have the announcement of the counsel for Rivera, please.
Yes, Your Honor. Morgan McFeeters for the appellants.
Thank you. And Ms. McFeeters, I trust that you got a notice that said that you would have 15 minutes aside. Is that right?
Yes, Your Honor. And I have reserved 5 minutes for rebuttal.
Okay, so it's 10 and 5. Thank you very, very much. And for the City of Houston?
Good afternoon, Christy Martin, appearing for Appalachia City of Houston.
Okay, and Veronica Romero. Yep. Okay, thank you very much. Well then, Ms. McFeeters, whenever you're ready, we're ready.
May it please the court. The court should reverse the trial court's summary judgment because, number one, the City of Houston failed to conclusively establish its affirmative defense that it is entitled to immunity under the official immunity doctrine because there remained fact issues as to whether Officer Romero was performing a discretionary duty on the one hand, and second, there are fact questions that remain as to whether she was acting in good faith at the time that this car crash occurred. Additionally, in their response brief, the city has argued that the court should nonetheless affirm the trial court's judgment on the basis of the emergency exception, which was another ground for summary judgment that was presented, which the trial court expressly rejected. And we argue that the trial court did correctly find that the emergency exception does not apply here. And so we ask that at least on that basis that the trial court got it right and should be affirmed on that ground. So turning to the first issue, the question of this discretionary duty. So generally speaking, official immunity protects a police officer from personal liability arising from the performance of a discretionary duty that is performed in good faith as long as that employee is acting within the scope of their authority. So as I mentioned here, the two issues are this question of was she performing a discretionary duty and did she do that in good faith? This, of course, is an affirmative defense, and so the City of Houston was required to conclusively establish as a matter of law each element of that defense, and they failed to do so. Now, actions are either discretionary or ministerial. Discretionary actions are those that require some sort of personal deliberation or decision or judgment, while ministerial actions are those where your conduct is prescribed by the law and you don't have discretion as to how to act. As this court's sister court, the 14th Court of Appeals, has held in Gibbons, which is cited in our brief, generally speaking, operating a vehicle under non-emergency circumstances is a ministerial duty. It does not fall under this realm of discretionary duties because the law in context where we're not in an emergency sets forth how police officers are required to drive their vehicles.
Well, I thought there was an emergency in the form of a priority call.
So that issue, Your Honor, goes to the heart of really all of the issues in this case, is was there an emergency? Was she really responding to an emergency? And so there is a fact question as to whether this police officer at the time of the crash was actually acting under emergency circumstances or responding to an emergency call.
And how about acting within the scope of her duties?
I don't think that element is disputed. I think it's just the discretionary duty element and the good faith element.
Okay, thank you.
Yes, Your Honor. This question of was there an emergency, as I said, really goes to the heart of this appeal. It is undisputed that this police officer was responding to a different lower priority call while on her patrol shift. She hears a call for a priority 2 call go over the dispatch that's directed to a beat mate of hers. It's undisputed that she was not dispatched. She was not specifically requested to respond to this call. She just testifies that she decided she was going to, quote, check by on that call. But she's about 10 to 15 minutes away in what she describes as a completely different district. And at the time that that call dropped, it's also undisputed that she was on her way to pick up her partner at a different police station. So when this priority 2 call drops that the city argues forms the basis of this alleged emergency for this officer, it's undisputed that she decides to just keep going to her original destination. And while doing so, she actually testifies that she's going at or below the speed limit. So there's no evidence of urgency here. She is simply proceeding on as originally planned to pick up her partner. And as she's doing so, she comes across an area where there are 2 intersections pretty close to each other. And she stops completely, so she says, at the first intersection, which is a red light, and checks that all the cross traffic is stopped. When she gets that clear, she proceeds through that intersection. But then as to the second intersection, she admits that she decides to look down and start typing on her in-unit laptop computer while approaching and driving through this intersection. So ultimately, there is a fact question as to whether or not she was really responding to an emergency situation. There's evidence in the record that shows, in fact, that she was not, that she was still proceeding with picking up her partner, that there was no urgency, that she was not required or dispatched to respond to that other call, and that she was simply going to just check by once she had had time to still pick up her partner and then head that way. So the city, in its motion for summary judgment, failed to conclusively establish that Officer Romero was acting under emergency circumstances. So because of that, her conduct never got converted from the ministerial action of driving a vehicle to the discretionary action of, for example, responding to a high-speed chase or to some other type of emergency.
Ms. McPeters, you only need to prevail on one of those 3 prongs, correct? They would need to establish conclusively all 3 prongs. So if we agree with you as to the discretionary duty prong or the good faith prong, then you would prevail. Is that right?
That is correct, Your Honor. And they face similar issues with that second prong of the question of whether she was acting in good faith. And I know I'm running close on my time, so I'm going to jump to that other prong as well. The question of good faith balances the officer's conduct with 2 different factors: the need and urgency presented by that situation and the risk to the public at large, the risk posed by the consequences of that action. So here, it is undisputed, rather, that, again, she's not responding to that emergency call. She's on her way to pick up her partner. She's going at or below the speed limit. She was not dispatched to respond to that call. She was simply going to check by. There's testimony in the record that talks about how typically a beatmate would respond and check by another beatmate's call unless that call went out to a 2-man unit. Well, there's no evidence in the record, and the city didn't establish whether this was a 2-man unit or not, thereby actually requiring her to respond. And indeed, after the crash the next day, Officer Romero admitted that she was not responding to an emergency situation and she was not on an emergency call. So her conduct here demonstrates that it demonstrates by her not driving straight to assist this primary officer on this call, which was in a completely different district, which was 10 to 15 minutes away, that we don't meet that need and urgency factor. And there's at least a fact question on that.
Is there anything in the record about the department's policy about entering information on the MDT while driving?
So there's not, Your Honor. There is not specifically. The city points to testimony from Officer Romero and Lieutenant Chen that says that it's preferable for officers to use the MDT rather than to clog up the radio where the primary officer may be trying to use the radio. However, nothing in the record establishes conclusively that it is reasonable and accepted and would constitute good faith for an officer to use the MDT while driving, and especially particularly to look down and type on the MDT while approaching and driving through an intersection, particularly where an officer has the red light. And so I think that's the big problem here, is that this officer makes a conscious decision to look down, type on a laptop while approaching an intersection. There's a fact question as to whether she had her emergency lights engaged at that time. All of these things come together to show that there is at least a question as to whether it was reasonably prudent for this officer to act in this way, and that there is at least a fact question as to whether any reasonable officer could have thought that this was proper to do. I see I'm about to run out of time for my main argument, so I'll yield the rest and speak to you again on rebuttal.
Thank you. Okay, Ms. Martin?
Good afternoon. May it please the court. I want to start with counsel's suggestion that there's nothing in the record about policy of typing on the MDT while driving. That is not accurate. We presented the evidence of both Officer Romero and Sergeant Chen. And Officer Romero said that it is for the safety of officers who are the primary responders that she prefers to use the MDT to communicate her check-bys so that the radio is free for in case that primary responding officer is confronted with an emergency situation that heightens what they're responding to. And Chen's affidavit confirmed that officers are encouraged to report their check-bys through the MDT so that the officers who are the primary responders will have the radio open if they need to communicate with dispatch more urgently than that.
But nothing in the record about that preference while driving.
It is, yes, it is. Officers are encouraged, and Chen testified that another reasonably prudent officer, including himself, could have believed that the need to get to the scene of this disturbance with a weapon justified her actions while driving. Officer Romero testified that another reasonably prudent officer, including herself, under the same or similar circumstances, could have believed that the need to reach the scene outweighed the risk of her typing on the MDT. And what we're looking at in terms of typing while driving, this is classic official immunity. You are weighing the need to get to the scene to help your fellow officer, to help the citizen who's reporting a disturbance with a weapon, and you're weighing that against the risk of taking your action while you're driving en route. And that's really what it's about. For the safety of the officer who's the primary responder, she elected to use the MDT. Perhaps that was more risky than using the radio to communicate, but it was done with a balance of the safety of the responding officers and the people at the scene versus other people on the road. That's what official immunity is designed to protect officers who are making these split-second decisions without fear of liability. She made the decision to communicate through dispatch through the MDT rather than the radio. To the extent that was negligent, negligence does not defeat the official immunity defense. And the only way that appellants could have raised a fact issue is if they had presented testimony that no reasonably prudent officer could have believed that the need to get the scene outweighed the risk of typing with dispatch on the MDT while traveling.
What about, sorry, Ms. Martin, what about while doing all of that while not knowing whether the light is red or green?
Right. The transportation code permits officers to proceed through intersections on a red light, so long as they slow as necessary for safe operation. And the testimony in the record was that even though, so at the first of the two intersections that she went through, she came to a dead stop, observed other cars yielding to her emergency vehicle, which at that time had emergency lights and siren activated. She gets to the next intersection, she slows, she tries to observe for cross traffic, she sees none, and she proceeds into the intersection. And in the intersection, at a minimum, her lights were activated and her siren was activated. And it was only on the other side of the intersection that the plaintiffs T-boned the rear of her vehicle. So the fact that she didn't realize her light was red doesn't preclude application of the official immunity defense, because she complied with the need that she slow as necessary and look for cross traffic.
It just, I guess I'm struggling with the idea that she can be typing, not knowing whether she has a red light or a green light, somehow typing, not knowing that, and looking both ways up to cross, and that's still just being negligence.
Right, and that's where we get.
I guess if you could help me out, how do you make of the Gibbons case?
So the important part about Gibbons is the words absent other circumstances, right? So Gibbons was, you are doing a ministerial act if you're just driving your police car on non-emergency business and there's no other circumstances. So those circumstances need not necessarily be an emergency. The 14th Court of Appeals, in a case that was after Gibbons, I think it was the Collins case, expressly rejected the notion that there must be an emergency for official immunity to apply. So even in the absence of emergency circumstances, you can still have a discretionary act. And Gibbons is nothing more than the uninteresting proposition that there has to be something else. And here we have that something else. And so Houston met its initial summary judgment burden to establish discretionary function, as well as good faith, because we had the expert testimony of both Officer Romero and Sergeant Chen. So that shifted the burden. And I think that's what's really important here. We had a shift of burden. And when that happens, plaintiff has to create a fact issue. And Judge Landau was correct that if plaintiff had created a fact issue on either discretionary function or good faith, then there would be a fact issue on official immunity.
Well, didn't the trial court deny discovery to the other side and the opportunity to do depositions, to discover facts and to raise them, so that you have the unopposed testimony of Romero and Chen? Didn't that happen?
Right. The trial court denied a motion for continuance to conduct discovery, which included the deposition initially of Officer Romero and then later also Chen. The trial court did not abuse its discretion. And the key is there were dates given for those depositions, and opposing counsel chose the last date that was given, which happened to be after the summary judgment hearing. And
the judge hurried up and heard your summary judgment before a scheduled deposition was allowed to be taken, as I understand it.
That's sort of correct. What the court, there was a hearing on the motion for continuance, and then there was a renewed motion for continuance, and the court denied.
It wasn't necessary, evidently.
Right. So the problem is the court was never given evidence of due diligence in pursuing that discovery. And so without an explanation for why the deposition couldn't have taken place on the earlier dates that were offered, then the trial court
didn't. It was an offered date. That's what I find so very troubling.
I'm sorry. Can you clarify that?
The date was offered. Then it's jerked back by the court after it's been offered. That's pretty extraordinary, in my view. To deny discovery under those circumstances, it's been scheduled on a date that was offered. But nevertheless,
there is
another question, and that is, you say that the only way that you're entitled to summary judgment on what a reasonable officer would do, unless Romero establishes that no reasonable officer could ever do this. And frankly, I really would like to hear what you have to say on this, that it's my understanding that what a reasonable officer would do is a classic fact question. And my understanding is that the only reason the other side would have to establish that no reasonable officer would do what the officer in this case did. I think I said Romero when I meant Rivera a minute ago. The only that would establish what the reasonable officer would do would be that if the Riveras were seeking summary judgment of their own, then they have the burden to conclusively establish that no reasonable officer would do this. But for you all to get summary judgment, wouldn't you have to establish that every reasonable officer would do this?
Absolutely not. That is not the case law.
All right.
And I want to jump back a little bit to your question, because the standard is not what a reasonably prudent officer would do. That's a negligence standard, right? Mm-hmm. Official immunity is a much higher burden. The standard is not what a reasonable officer would have done. It's what a reasonable officer could have believed, right? And the Supreme Court has reiterated over and over again that it's a really high burden to overcome, and that's by design. We don't want officers making these split-second decisions because in the moment there's a set of facts that they believed to be one way. And then Monday morning comes around and all the Monday morning quarterbacks say, well, no, that wasn't reasonable. You shouldn't have done that. The Supreme Court has said, no, that's not what we do. And so our summary judgment burden was to establish that any other reasonably prudent officer could have weighed the needs and risks as Officer Romero did. We met that burden. To overcome that burden, they have to establish nobody would have done that.
I see.
And
well, they don't have to establish it, do they? Don't they just have to raise a fact issue about that?
The only way to raise a fact issue is to present expert testimony that no reasonably prudent officer would have done that. That's what the Texas Supreme Court has said.
Well, hold on. I mean, I'm not quite sure what to make about the conflict in the city's own evidence where Officer Romero says herself that she was not responding to an emergency.
Right. So that evidence was excluded by the trial court, and this court can't consider it unless this court finds somewhere that there was an abuse of discretion for the judge excluding that evidence.
What was
So
his reason for excluding that evidence?
it was hearsay. It was an out-of-court statement offered for the truth contained in the document. The judge struck it as hearsay, and the briefing on appeal that said, wait, this is an admission of a party opponent or a statement of a party, that was never presented to the trial court. And so that issue is waived. The 14th Court of Appeals in the Cruikshank opinion that we cited in our brief is squarely on all fours. If there's a hearsay exception or a hearsay objection, that is sustained, and then the responding party doesn't present a response to the objection in writing for the summary judgment proceeding, and also does not put in their motion for new trial that, wait a second, this is not hearsay because it's an admission of a party opponent, then you can't raise that for the first time on appeal. And that's what they've done. So
well, let me move to a different piece of evidence. The city's own internal report was not excluded. Is that correct?
It was excluded. The only evidence in the record that the trial court didn't exclude was the affidavit of Romero, the affidavit of Chen, and the crash report.
That's what I mean, the crash report.
Okay.
That found Officer Romero was at fault in the accident.
Right. Being at fault does not create a fact issue on either official immunity or the emergency exception. For official immunity, again, it's not a negligent standard. It's a higher burden than that. So there's no fact issue raised, even if she was found at fault in the crash report. Secondly, for purposes of the emergency exception, there's well-established case law that I'm out of time. Can I just finish this one thought?
Yes, please.
There's strong case law, I believe, that the Sparks and the Spears case, I think they're both out of the 14th, that a finding that an officer failed to use due caution or was at fault or was a contributing factor in a crash report does not create a fact issue as to reckless disregard. So I see I'm out of time. If there's no further questions, I thank you for your time.
Thank you. Okay, Ms. McPeters.
Thank you, Your Honor. I just want to address a few points that the city has raised. Number one, the city argues that this policy of allegedly allowing officers or encouraging officers to type and use the MDT while driving is for the, quote, safety of the officers. But the question before the court requires it to look at more than just what was required or suggested or preferable for the safety of the officers. It requires the court to look beyond that and look at the risks posed also to the public at large and the safety of others. It also asks the court to look at what other alternative courses of action were available to this officer that a reasonably prudent officer could have taken. For example, here, if the policy really is for officers to use the MDT rather than to use the radio to announce that they're going to check by on another officer's call, this officer could have pulled over. She could have typed while stopped at one of the multiple red lights that she ran on the way to pick up her partner. She could have typed even while driving, perhaps, but once she was through this area where there were multiple intersections. There is no appreciable benefit or time that she gained here by choosing to look down and type while driving through an intersection, especially where her conduct caused a wreck because it was reckless. So that prevents her from reaching the scene to help the other officers altogether. She can't help if she's caused a wreck because she's looking down at her computer while going through an intersection. Additionally, the city pointed out that the transportation code requires officers to slow as necessary when passing through a signal-controlled intersection. this officer could not have slowed as necessary because she admits that she did not even know that the light was red. It is just factually impossible for her to have slowed as necessary to safely cross an intersection where she does not know that cross traffic is coming and she does not know that the light is red. And she admits as much.
Well, how about the argument of the city that her admission is inadmissible?
She admits as much in the crash report as well. So that evidence is not just included in the form that the officer filled out the next day or the other collision report. It is also in the crash report where the officer squarely admits, I looked down, I didn't realize I had a red light until the moment of impact. The impact was what startled her to look up and realize the light was red.
As she passed through an intersection looking down at her machine.
Yes, Your Honor.
Right.
Additionally, I just want to briefly mention the, I'm sure I'm going to mispronounce this, but the JARP case out of the Amarillo Court of Appeals. The petition for review in that case was recently denied by the Texas Supreme Court. And in that case, where the facts are really pretty similar to the facts that we have here, there's an officer who is not dispatched to a call, but he's going to go check by on it. In addition to two other officers, there's dash cam of him once he gets this call, just sort of calmly walking to his car. And then once he's in his car, he's speeding and he admits he looks down to view his computer in his vehicle. And that's when a crash occurs. And in that case, the Amarillo Court of Appeals said that the city failed to conclusively establish and that there was a fact issue as to whether any reasonable officer could have believed it was appropriate to look down at the MDT while driving through an intersection. And the court talks about how this is not just a momentary lapse of judgment. This is a conscious decision. Every driver in the public knows that it's a matter of common sense. A distracted driver is a dangerous driver, even momentarily. And while typically a momentary lapse of judgment is not enough to rise to the level of reckless conduct, the court says that the decision to look down while driving, while approaching an intersection, was beyond a momentary lapse of judgment. This was a choice that the officer in that case made. It was a choice that the officer in this case made. So for all these reasons, we would ask that the trial court summary judgment be reversed because fact issues remain, and these appellants should be permitted to continue discovery and to proceed with their claims. Thank you, Your Honor.
Thank you very much, both sides in this, for very good argument. Case number 19-00629 CV, Elmer Rivera et al. Versus City of Houston and Veronica Romero is submitted. Thank you.
Thank you, Your Honor.
So if the lawyers would please leave, I'd like for Judge Landau to stay on for a bit.
Thank you.
Okay, thank you. You can see that makes me